which is the process, the power and the process. The power is in 370 sub-article 3. The process is what they followed. Can they do it under 370 sub-article 3? And is this process right? That's the limited issue that your lordships have to decide.
The populace of the Jammu and Kashmir are taken into consideration. The abrogation of 370 can't be
yes,
touched
that
upon.
can be done. But that's
then the negotiations were not between.
No, not
could meet the mandate. Question is, you say it can't be done.
No, I say this was a political act. I don't say anything more than that. Your lordships were to say this is not the right procedure, then the question will arise, can they do it through any other procedure? Then what my lord is putting to me may arise. But we're not on that issue. We're not giving solutions to the other side that you can do it under 370. I don't know where that comes from. So there's a limited constitutional issue before you, which is the process, the power and the process. The power is in 370 sub-article 3. The process is what they followed. Can they do it under 370 sub-article 3? And is this process right? That's the limited issue that your lordships have to decide. If there are other processes available under the Constitution, if they follow them, maybe, but that may be valid, may not be valid, but I can't answer that question in a vacuum. But my lord is right. What my lord is putting to me, the problem is the residuary power is with the state, and I've shown your lordships, Mullad's provision after provision, right from the Delhi Pact in 1952, that's the case.
But then what happens to Article 363A?
350?
363A. Because that also earlier the recognition was on the basis of the pact between the various princely states and
different. Mullahs, those pacts were there, recognition granted to rulers, but Mullahs, either they completely assimilated themselves into the union and be part of a state, or they were taken over. Either Hyderabad or Junagadh.
On the basis of certain agreements between the states and the princely
correct,
states.
but those agreements were different from this agreement. Mullahs, your lordship is right. If it were that kind of agreement, then your lordships would apply those standards and those principles and those judicial dictums which your lordships apply. We're not on that.
Here your argument is that unless the views of the entire populace of the Jammu and Kashmir are taken into consideration, the abrogation of 370 can't be touched upon.
Yes, that can be done. But that's
then the negotiations were not between the elected body. The negotiations were because the princely state and the union.
Correct, and that was accepted. That very thing was accepted by the then constitution makers. So, whereas we can't go into.
So, if what was accepted, insofar as the other states are concerned, it could be taken away by 363A.
Correct, but that was not the position as far as Jammu and Kashmir is concerned. I'm not saying anything. I agree with what my lord is putting to me. But how do you change the constitutional structure? There must be some power. You can say that you can do a political act. Today you say, look, forget about all this. We take over Jammu Kashmir. Fine.
363A was done under 368.
Yes, you can do that. But point today is, Mother, that's not an issue before you. You're not going to answer an issue which is not, with respect, the greatest respect, which is not before you. You're not going to find a power for them which doesn't exist and which is not followed.
Yes, Mr.
Go back. I understand, Mullahs, the difficulty, and I understand, Mullahs, the fact that at some stage or the other, this had to be, let's put it this way. This had to be done. Let's put it this way. Somebody said this has to be done. So then Mullahs, there must be found a constitutional way of doing it. I'm not saying there are.
It has to be done, I would say, but whether it could be done or not.
No, not could
meet the mandate. Question is, you say it can't be done.
No, I say this was a political act. I don't say anything more than that. This was a pure political act. And you circumvented the provisions of the Constitution to reach a particular end result, which you always wanted.
That's the second part is that, which you will argue, of course, that the
Yeah.
process by which they followed was.
Yes, yes. Well, that is the issue before you. There's no other issue before you.
According to you, this could have been only done on the recommendation of the Constituent Assembly. Absent a Constituent Assembly, you cannot exercise the power to abrogate.
Number one. Number two, in any case, it is they who believed that this could only be done through the Constituent Assembly. Apart from the fact that I say that it could be done, they also believed that it could be done, and they followed that procedure. Now, whether that procedure was right, was wrong, is for your lordships to decide. Whether there is another way to do it is something that they will decide. That's all that I can say. I don't want to make the argument in a hypothetical argument, conjuring up issues that don't arise in this case. And I don't want to give a helping hand as my learned colleague wants to do, because he can do it outside the court.
The lighter side, you said if you had to do it, you would do it a different way.
Maybe. But you can't introduce a bill in Parliament at 11 o'clock, pass a resolution without anybody knowing about it. Of course, those are internal procedures.
You're the Parliament.
I'm not saying anything.
Article 212.
Yeah, so I'm just saying, 11 o'clock,
Or as
nobody
a-
knows. Nobody knows.
Larger issue, as a member of Parliament, you will say, don't touch us.
Yes. That's right. So I'm not touching that process either. I'm only saying that this is what, it sort of fits into the argument that this is was a political process carried through certain constitutional means, which unfortunately were not available.
Always a political process, Mr. Sibal. Only question is whether it is within the constitutional means or not.
That's right.
Everything is a political process.
No, I'll tell you how, Manoj, because now let me just go through Coelho and then I'll go back to the list of dates.
Yes.
Why? Because you're subject to the constraints of the Constitution. So you want to amend, you can use 368, but then you have to follow the procedure under 368. But so, for example, if you were to say that you amend the definition and say the provision for consent of the states is not required. Approval of the states is not required. Can you do that? The answer is no. That's a proviso to 368. So if you want to work within the Constitution, you have to follow then what the Constitution obliges you to do constitutionally. If 368 were available.
All right, apart from Coelho, which is the next?
Yes, next is 100. Exactly.
There's only one part in Dr. Ambedkar's statement is very prescient. Dr. Ambedkar postulates that a future Constituent Assembly may be a future Parliament itself.
Yes.
Says the future Parliament, if it met as a Constituent Assembly,
Yes.
its members will be acting as partisans, seeking to carry out amendments to the Constitution
Yes.
to facilitate the passing of party measures which they fail to get through Parliament by reason of some article of the Constitution, which has acted an obstacle in their way.
This is
That
the
is
precise
difference between
argument.
the Constituent Assembly and the future Parliament.
So this is the precise argument I'm making, is what Dr. Ambedkar said. That it is the parties' partisan political measures that are carried through in the process in the form of legislation or otherwise, which can't be done as far as which will be constrained by the provisions of the Constitution, but the Constituent Assembly doesn't have any such fetters.
Yes.
So, Mullahs, I'm done with this whole argument, Mullahs. So now let's go back to the list of dates and how all this happened, the other issues. Now compilation.
We go to
In my written submission.
your written submissions, volume
Written
2.
submissions, volume 2. And kindly come
Page
to
48.
the page 47.